Present in the virtual courtroom, we have both parties along with their respective attorneys, Ms. Van Dyken on behalf of the plaintiff, Ms. Cutzley, Miles Murphy on behalf of the defendant, Mr. Cutzley. We are here on a couple of issues. First is the defendant's objection to the ex parte order that the court issued, as well as a motion for an order to show cause. Mr. Murphy.
Yes, Your Honor. I'll handle that objection then first, please.
Okay.
Your Honor, under MCR 3.207, it's our position that there has been no showing of specific facts by way of a short 3 to 4 paragraph affidavit or the bald allegations of Ms. Van Dyken of any irreparable injury or loss or damage. And we are asking the court to dismiss the ex parte and phase back into what's already in place, the stipulated temporary order, which was entered back recently in the case on 8/26 of 24. I would note there is an STO, which I just noted. The plaintiff did obtain a PPO, which entered on 9/25 on the heels of the ex parte, apparently. And again, we have strongly opposed and objected to the PPO, which is now scheduled for hearing in a few weeks. Bottom line, Your Honor, this is a very high conflict case. The parties have been separated since roughly April to May. They have this auto body business. Fortunately, to my knowledge, there is not an issue regarding their 2 children. So it's an issue dealing with property and debt. My position on the objection is that the ex parte unreasonably handcuffs the defendant, my client. It prevents him from his livelihood for a business that he founded and or bought in 2008. And the parties got married in 2015. We have at least 7 to 8 years of premarital interest in this business. My client was always the one with the mechanic's license. He developed the business, he nurtured it. Plaintiff Janelle did enter the business a few years ago. The reason my client was temporarily out of the business in roughly the summer of 24 forward was because the parties had talked about Janelle buying out my client's interest. Now that's totally off the table. We're not in favor of her buying out the business because it's going to go under. The business is being wasted. It's being mismanaged. Employees are being improperly treated. And there's a lot of financial red flags, Your Honor. The red flags are something that I can, again, just reiterate. I won't rehash things, but in my motion for an order to show cause. So we're respectfully asking that that the ex parte be dropped and that my client be permitted to have access to the business. And the relief that I am going to be asking for also in my motion to show cause includes a couple things that the parties have been exchanging information on back in August. They had settlement negotiations, which are private. They did fall through, but based upon those negotiations, my client agreed to let Janelle come in and operate the business short term. It has not been going well. Also, my client had agreed to, they have about 5 or 6 other properties. My client agreed to build and move forward with a house in Kent City for the plaintiff to move into. That has started, but there have been delays on the foundation and the sanitation issue. But we think that can be solved by number one. Right now, the parties are living next to each other with a PPO in place. The marital home is next door to the defendant's parents' home. About 100 yards or so separate them. So that's caused some conflict. We suggest that plaintiff move either into her mother's house or that defendant be permitted to move into their duplex. They own a duplex on Maple Street, I believe in Sparta. That lease terminates on November 1 with a renter. my client would be able to then move away from Janelle and into the Maple Street address starting on or about November 1. I believe Janelle had opposed that as of now. So, Your Honor, we are asking the court, I'm not trying to be long-winded, but there are a lot of pieces in this. We do have mediation set now for November 25 with Mary Benedict. That's definitely needed. We respect the PPO, but we are objecting to the PPO. And we're stating that the plaintiff's own unclean hands or bad faith and inadequate showing of specific facts justify dismissal of the ex parte order, Your Honor. Thank you.
Ms. Van Dyken.
Thank you, Your Honor. All of that is false. The business is going very well. I think the court has reviewed the pleadings, letters written by employees about Mr. Cutzley's lack of engagement in the business. Even yesterday, he called one of the employees and tried to bribe him not to come to work. That's Rodney. Yeah, Mr. Cutzley, he let us know. This man has gone in and just taken funds from the business that he is not working at, nor is he working on the Kent City home. What he did do is the Maple Street home, he went and unilaterally told the tenants, you can leave, we'll let you out of your lease anytime, where we had leases. So he's unilaterally doing things to impede funds coming in to the family. He can stay at his parents' house, it's right next door. This court signed a PPO violation just yesterday. Mr. Miles, Mr. Murphy, check your email. He's got a violation of the PPO. He is not appropriate to run this business. He lies to you in pleadings that he completed rehab. He left after 36 hours and got a refund. From April of 2024 through October 4th of 2024, Mr. Cutzley was paid about $48,000 from the business that he was not running, that he was not taking a part of. But what he has done is tried to bring down the business by taking funds out for his own personal use, bribing employees, scaring employees, showing up drunk to many things, tearing down cameras, filing false police reports at their cottage and here in town. Just last night, he called the cops for a welfare check on his child living right next door. This man is in no condition to run this business. I believe the ex parte should stay in place. He has access to all of the information through Mr. Roger Boersma, their CPA. He's been the CPA for the business for 40 years. He can have access to what's going on, what's being paid, what's not being paid. But right now, my client's responsible for making all the payments on everything. It was Mr. Cutzley who unilaterally one day, probably drunk, called up the electrical company and said, turn off the power to my house. And so my client's in the house with the kids, one of them sick with 101 fever, with no power. He's doing everything to put up hurdles in this divorce. These parties were working on an agreement. I would agree with Mr. Murphy, but that's no longer on the table because of all the shenanigans that Mr. Cutzley's been paying. Your Honor, I'd ask the court to keep the ex parte in place. I'm happy to talk with Mr. Murphy and the CPA about what's been happening with the company, what's been coming in, what's been going on. My client's trying to run that company. He's doing everything to stop it. He took the dump truck that they utilized for the company to take away all these parts and scraps. They can't do that now. Now they're piling up. He's not fit to run this company. He's not. Quite frankly, I'm pretty concerned that he hasn't finished his rehab. Mr. Murphy says he did, hasn't provided anything. We know he got a refund check from rehab. I don't know which rehab sends a refund check when you complete rehab. And what rehab
repeating
goes
herself
36
here.
hours. So he has money because he got a refund from the rehab of $1,900. The ex parte needs to stay in place. My client will plead not guilty to the order to show cause. We can set it up for hearing. Quite frankly, we do need to get into mediation on all of this.
Your Honor, again, I would just respond briefly that my client has run the business since 2008 for 18 years. He has been the primary operator. He removed himself a few months ago because of a informal divorce discussions. Now that's off the table. He does want to run the business because he sees what is going on. It's going in a terrible direction. And I would just note that, make no doubt, the business is a priority. His family is a priority. Respecting the court orders is a priority, but protecting KBS is an absolute priority here. So I would ask that the ex parte is not necessary and that it be removed.
All right. The court finds that the plaintiff has met the requirements of the court rule MCR 3.207. The court is very concerned about the finances of these parties, and obviously on a Friday morning it's very difficult for the court to figure out what exactly is going on. That's really an issue for trial. I really encourage the parties to make the best use of this mediation that's coming up, because this litigation is going to take whatever money the parties and assets the parties might have available, and dissipate them just through litigation alone. So I just really encourage you to try to work this out yourselves. And I will deny the motion order show cause.
Thank you, Your Honor.
But
Honor,
I do encourage the parties to share information regarding finances through this accountant or however that needs to happen.
Your Honor, and I know you have a busy docket, but on the motion for an order to show cause, we had outlined a number of red flags that we tried to, again, highlight about problems and concerns on page 3 of my motion. Again, my client is being paid nothing. His monthly draw and his weekly paycheck have been cut. He has no other income right now, and she has hijacked the business.
I understand all of that, but I also heard that he's received significant amount of money in the past couple of months, and that he received a fairly significant refund from the rehab facility. You do have mediation coming up in a couple of weeks, and I think that's where this needs to be worked out. We are
Thank you, Your
here
Honor.
on the defendant's motion to set aside the default judgment that was entered in this matter. And if I understand correctly, Mr. West, you are saying that Ms. West failed to serve the proposed order or the proposed default judgment and notice of hearing as required by the court rule?
No, she may have sent it, Your Honor. I was not at the house. I did not have a residence at the time.
I sent brother.
Ma'am, it's not your turn to talk.
I'm
Let him
sorry.
finish. Go ahead, Mr. West.
I just want things to be peacefully, Your Honor. So I'd like to drop everything. She can have everything, Your Honor.
So you're no longer objecting?
No, the only thing I would ask is that my name be removed from the house, and that my name will be removed for the bill. She can have everything.
Ms. West?
I'm already, I have no problem with that. I was under the impression that he wanted the house, so I have moved out of the house as well. So I just asked the same thing that I wasn't, because the motion he filed, he said he wanted the house. So I thought he wanted the house. I have no problem with any of it. If he wants to drop it, I have no problem with that. And we can work out whatever needs to be worked out. I don't have any issues working out whatever needs to as far as the house goes. It's being leased. It's not we don't own it. So
okay, then no, that doesn't get addressed in the judgment of divorce then.
Yes, ma'am.
So you don't own any real property?
No.
Only the furniture in the home that, no property.
And you can have the property. You can have whatever you want from there.
I don't want any of it.
Okay. All right.
I just want my name removed from the lease. I sent out a document and they said that she needed to sign it as well. I haven't lived in the house since July 31st. So we can both move forward peacefully and amicably. I just wanted to be removed from that and have my name removed from the bills.
Okay. All right. I'm looking at the proposed judgment. I don't see anything in here that is any different really than what's already been talked about. And if Referee Perry did approve this, so I will enter the judgment. And I will dismiss the defendant's motion to set aside the default since he has indicated on the record that he no longer wishes to pursue that. All right, we are adjourned. Best wishes
Thank
to both of you.
Thank you.
Is there a way that I can have that where I can be removed, Your Honor, the lease, the property
Well,
management group?
That's
Both be
not that,
removed.
ma'am, you can't keep interrupting. That is not something that the court has any authority over. Okay.
Okay.
So that you've got to work that out with the landlord.
Got it.
Both parties are
Okay.
present in the virtual
right.
courtroom along with their respective attorneys. Mr. Sherlin on behalf of the plaintiff, Mr. Volpetti, Ms. Wagner on behalf of the defendant, Ms. Volpetti. We are here on the defendant's motion to enforce the judgment of divorce and to send the children to counseling. Ms. Wagner, I have read both the motion and the response, by the way.
Thank you, Your Honor. I'll just respond to Mr. Sherlin's response rather than reiterate my motion. But I think ultimately the purpose of our motion was to get the children into counseling. There are some significant concerns from Ms. Volpetti. She does indicate that, and I've listened to, she has a recording of Mr. Volpetti calling her a whore. So his denial of that is a flat out lie because it's on an actual recording. She has text messages where he's stating that he booked their son for a counseling appointment, and her response is that it would have been nice if you would have consulted with me. Like she had no say in the process. She didn't object to the counseling, but she didn't have any. It was not a joint decision, and there's text messages to validate that. Her youngest most recently just told grandma that daddy has a secret about mommy and that she's done something bad. This is a regular reoccurrence with the children, is this theme that mommy has done something bad. And she even has a text message from May 17 where he says, "Will you lie to them when they ask about your infidelity? Good thing I saved all the messages to show them when they are old enough." And so while it's clear he doesn't necessarily intend to tell them until they're older, the mere fact that he's indicating there's something to tell them is so unbelievably inappropriate. So because of all of this, we really feel the children, both of them, need to be in counseling. She did look at the proposal from Mr. Sherlin's office, and she was in support of the office and would prefer to use Taylor Broadbeck from that office after having reviewed all of the bios that are listed on the website. So ultimately, I would just ask that the court enter an order for the children to engage in counseling and for that to be with Mr. Broadbeck, if that's acceptable to Mr. Sherlin. And just gently remind Mr. Volpetti that it's really inappropriate to be talking to the children about anything as it relates to the divorce other than just mom and dad are no longer together and it didn't work out.
Mr. Sherlin.
Thank you, Your Honor. I think that we agree that the communication to the children is when they ask, and my client reports that they do, that mom and dad aren't together and both parents love you. Look, the facts of this case are, the history of this case factually is that Ms. Volpetti did end the marriage because of her infidelity, but it's not that the children need to participate in that or know that, but they ask questions about why aren't mom and dad still together. My client tries to answer them in an age-appropriate manner that says, well, mom and dad didn't get along, or mom and dad needed to live separately. That type of generic response to the children of this age. My client is very concerned that the therapy is just a fishing expedition to try to make some sort of, case against my client. And it's really strange that the defendant actually asked to use a therapist who was the couples counselor for the parties prior to the divorce being filed. And the only reason my client can think of that would be the request of the court is because that particular counselor, from my client's perspective, kind of ganged up on him and almost defended the infidelity by Ms. Volpetti. So my client strongly disagrees with the court or with the defendant that he's in any way involving the children in the facts or the history of the case or the actions of Ms. Volpetti. But, admittedly, Your Honor, my client was really hurt by the actions of Ms. Volpetti. There's no doubt about it. But he's been working on that and he's processing that. And I think he's getting to the point where, and he is to the point, he tells me, where he's accepted the history of the case. And it's really just a matter of parenting. He tells a very different story about the counselor that the parties tried for their son. He found the counselor, arranged the counselor, and thought he had the agreement of Ms. Volpetti. Apparently now she's saying she didn't agree, but she didn't object. I don't know what that means. But their son did see that counselor, and that counselor reported that it didn't seem like there was anything that really needed to be worked on. My client tried another appointment, and the party's son became very upset about the idea of going to another appointment. And that's where it was left. My client did the right thing when he was hit with this motion, as opposed to, say, a request or communication about, can we talk about counseling? When he was hit with this motion, he contacted the children's teachers and said, hey, how are the children doing? And forwarded the emails to me. And both teachers give glowing accounts of how well the children are doing. And certainly, the court's done this long enough. We've all done this long enough that we know if these children are struggling, it shows up at school. And there was no equivocation at all by the teachers that they're great kids and they're doing very, very well. So I did not offer counseling in the motion response. What I offered is if the court believes that counseling needs to be pursued, that I had on a prior case very good experience with Martinos as a husband and wife counseling team. It's interesting now, though, that Ms. Volpetti says, well, even if we do counseling, I don't want to use those people. And I think, honestly, it's because her angle on this is to weaponize the counselor as opposed to a true therapeutic approach. A true therapeutic approach would keep the children's information confidential, and it wouldn't be seeking information or an alliance with a therapist to promote future litigation. Well, my client feels like he has done the due diligence here and has checked with the obvious sources that would tell him whether the children were suffering or dealing with any issues that needed to be addressed in counseling, and he didn't find it. So I would ask the court to deny the motion regarding counseling. In the alternative, if the court decides counseling is appropriate, I think the Martinos would be, I'm only going by experience, and they were not therapists that I suggested in the case. It actually came from opposing counsel, and I was very impressed how they handled that particular very high conflict case. So the requested relief is to deny the motion. My client feels that the motion was unnecessary, that it could have been done through discussion between the parties. And, he's trying to fix his transmission on his vehicle right now. And these attorney fees are preventing that from happening, and would ask the court to consider whether this motion was well grounded in fact and whether the court would grant attorney fees to him.
All right, thank you. Well, this court believes that counseling is important for children who are experiencing divorce, both while it's pending and potentially afterwards as well. And so the court is going to order counseling for these children. I will indicate that the children should go see the Martinos. I'm also going to order that both parties, if they're not already involved in their own individual counseling, that they need to do that. The temperature in this case needs to be brought down to a manageable level. It's clear to me that there's still a lot of conflict, a lot of hurt feelings, all of that, and both parties need to work through that in the best interest of their children. Children pick that stuff up regardless of what is said or not said to them. And today I'm not going to get into all of that. Just that these parties pick up on the tension between their parents and they internalize it and they blame themselves. So I do want them to go to counseling. As I said, it'll be the Martinos, and I really believe that both parties need to also go to individual counseling to help them work through their own issues so that they don't spill over to these kids. All right, and I am going to deny the request for attorney fees.
Your Honor, will we, the out-of-pocket cost, I don't know if insurance will apply or not, but will the out-of-pocket cost be shared between the parties?
The medical, uninsured medical expenses part. My understanding is that most insurance companies will not pay for court-ordered insurance, so how the parties approach that is up to them.
So right now, Your Honor, the parties divide child-related expenses equally as a
All right.
deviation. And then will the Martinos, the counselors, set the horizon on this? In other words,
Yes. I always put the power or the authority, the control in the hands of the counselors as to how things should progress, how
Okay.
many visits, what it should look like, all of that. That's their lane. And I would expect that the children's counseling is kept confidential.
Okay, so the children's counseling is confidential, so we can't attach that counseling information to motions, for instance?
No.
Okay, perfect.
All right. We're adjourned. Thank you.
Thank you, Your Honor.
Present in the virtual courtroom, we have both parties as well as their respective attorneys. Mr. Judd on behalf of Ms. Quist, Ms. Wagner on behalf of Mr. Alvallero. We are here for a motion for a temporary order in this matter. I have read the motion and the response. Ms. Wagner.
Thank you, Your Honor. I will, as previously I did, I will just respond to Mr. Judd's response rather than reiterate my own motion. The parties have been in a long-term relationship and have 2 children. Their relationship ended many months ago, but they continued to live together until September of this year when plaintiff moved out. As I said, they have 2 children. My client has always been a very involved and engaged father. He has attended doctor's appointments on a regular basis throughout the pandemic. He and Ms. Quist would go to all of the doctor's appointments together. He hasn't been able to attend every single one. He does work full-time and has been the primary caregiver for this family. He has not had any parenting time since, well, I shouldn't say any parenting time. He has had very minimal parenting time. In the first few weeks after Ms. Quist left, he did see the children very sporadically and for a minimal amount of time. But since then, he has not been able to see them. Mr. Judd indicates that parenting time has been offered. It was offered last week, Thursday, with a proposed schedule. So it's not something that he was offered from the get-go or even 3 weeks ago. It was literally just last week, Thursday, that I received Mr. Judd's proposal for parenting time. He resides in a safe home. He also has the same pictures Ms. Quist has of an excellently well-maintained home that is safe for the children. He does have a roommate, and it is indeed his girlfriend. They reside together. She is a person the children are familiar with, and she is a person Ms. Quist is familiar with because she has been involved in this family's life and has provided support to the extent that when the family was sick, she brought over medicine for the family. So has both financially helped them and physically assisted them. Mr. Alvallero has been the provider, but simply because he worked is not a reason to deny him parenting time. He is an active and involved parent, and just as much as Ms. Quist deserves equal parenting time with these children and is able to care for them and able to provide for them, even if he is at work. It's not an acceptable answer to say that simply because he works, he shouldn't have his children. He can arrange for the same kind of care that Ms. Quist can arrange for if she is supposed to be working. So I would ask the court grant the parties joint legal custody and joint physical custody and follow a 2-2-5 parenting time schedule, and then would suggest that the matter of child support be referred to friend of the court.
All right. Thank you, Mr. Judd.
Thank you, Your Honor. I think it is totally untrue to say that he's been the primary caregiver for these children. Ms. Quist has essentially been a stay-at-home mom, having a part-time job and being home with these children. This idea that he is exercising the same amount of time with the kids or providing the same care is simply not true. I mean, we provided, I think, a dozen doctor's visits showing who that's with. She carries the health insurance. We provided 2 situations where one involving an umbrella, where she was then berated for having the umbrella in her car and not providing it to the children. Another one involving a water bottle that she didn't pack the night before, and so that was a big problem, and Mr. Alvallero wasn't going to provide that to his daughter because of it. I think the court can see through the text messages that we provided the flavor of the relationship. There will be 12, 15 text messages coming from defendant to plaintiff before she can even answer. This is what's happened in the home, and that's kind of what has gone on. If she isn't following his rules and his demands explicitly, then there are consequences. So she left the home. She's always been the primary caregiver of these children, and these children don't know his girlfriend. They shouldn't then be set into, okay, from the time school's out or until the entire time they're at work, or the entire time Mr. Avallero's at work, to spend that with her and then have her put them to bed. He's not home till 8:30 or 9 o'clock sometimes. These kids are in bed. That's not the case with Ms. Quist's home. She has, I think, one kind of afternoon time that she's working and some mornings after the kids are in school. One of those days being Sunday, which is the day that we were suggesting that Mr. Alvallero have parenting time. I think the parenting time that he would be exercising under our response is appropriate. It continues a good, strong relationship, but doesn't put these kids in a different home with a person they don't know for the majority of the time. So we'd ask that parenting time be awarded to Mr. Alvallero as we set forth, and that the parties, I don't have any problem being referred to front of the court for child support, although I think it's probably just as simple for us to exchange that income information.
Ms. Wagner?
I don't have necessarily a problem with Mr. Judd and I working out support. Other than that, if Ms. Quist is not working full time, I would ask that her income be imputed. And I think that issue would need to be resolved today before he and I go back and forth on support numbers. I still feel strongly that the parenting time should be a 2-2-5 schedule. The children will remain in the home when Mr. Alvallero is at work. They don't have to go to a daycare facility. They'll be cared for in the home that they will be familiar with. And I don't think that that's a reason to go ahead and deny him equal parenting time.
All right, thank you. The court will award the parties joint legal custody. However, the court will award the plaintiff sole physical custody, finding that the established custodial environment, based on the history, at least as presented today, of the parties' interactions, with the children, all of the custody factors, that those all preponderate at least to Ms. Quist's favor for the moment, based on the information provided. That the defendant be awarded parenting time from 9 a.m. on Sunday until before school on Tuesday every week. I do think that at this juncture, in this case, these children should not be left in a third party's care, at least until this case is resolved. So that he not leave the children with the girlfriend. The parenting time is for him. And that needs to be clearly understood. I will refer this to the front of the court regarding custody, parenting time, and child support, with the parties splitting the fees 50% each. And is there anything else that the court needs to address today?
I think we can probably work it out, but as far as transportation, Renee, are you fine with them kind of splitting it with the meeting places? I think that's kind of what they were doing before. I'm sorry, Ms. Wagner. Or we can talk about it afterwards too.
I think Mr. Judd and I could work that out. Yeah.
Okay.
All right.
Thank you. We're adjourned.